Hello, everyone. I hope you've had a really good second day at the conference. Welcome to this final panel for today at the Refugee Law Initiative 5th Annual Conference. This is our distinguished keynote speaker session. For those who weren't in the opening session this morning, my name is Professor David Cantor, and I'm the director of the Refugee Law Initiative. For today's keynote session, I'm truly delighted to welcome Professor B.S. Chimni, Distinguished Professor of International Law at O.P. Jindal Global University, Sonipat. Professor Chimni certainly needs no introduction whatsoever in a conference on refugee law. He's the leading authority today on post-colonial approaches in this area and has written extensively on international refugee law, international economic law, and international legal theory. Alongside many important academic positions, Professor Chimni has been elected an associate member at the Institut de Droit International and is a former vice president of the Asian Society of International Law. Last, but hopefully not least, we're really thrilled that Professor Chimni sits on the editorial board of the RLI book series on international refugee law. We're also honoured that he's conferred his name on a new B.S. Chimni scholarship that will facilitate access by disadvantaged students to our distance learning MA in Refugee Protection. The title of this year's conference is Aging Gracefully, the 1951 Convention at 70 years. The title of Professor Chimni's keynote presentation responds to this by addressing the 1951 Convention at 70, a post-colonial perspective. I know we're all really looking forward to hearing what Professor Chimni will be saying under this title. The plenary will proceed with the keynote presentation of about half an hour, after which Professor Chimni has kindly agreed to respond to selected questions and comments from other conference participants. So during the session, please do pose your own questions and comments to him by typing them into the chat box on Zoom, and I'll try and convey as many of them as possible to him once we reach the time for discussion. Please also remember to keep your microphones on mute. The session is being recorded and will be posted on the RLI website as a podcast. So if you don't wish to appear in the podcast, then please leave the session now. Professor Chimni, a delight to welcome you to the annual conference. You have the floor.
Thank you so much, Professor Cantor, both for inviting me to deliver this keynote address, as well as for that extremely generous introduction. I would, of course, like to also thank the Refugee Law Initiative, University of London, for extending the invitation. What I propose to do in my address today is to explore in the context of refugee law different approaches to responding to the question whether the 1951 Convention is aging gracefully at 70. I suggest that there are at least three ways of approaching this subject. These I label for convenience an internal approach, an external approach, and a dialectical approach which takes cognizance of both. The dialectical approach makes recommendations focused on what is possible in the short term without abandoning long-term ambitions of ushering in a just global refugee regime. I will touch on these three approaches from a materialist post-colonial perspective and argue that the 1951 Convention could have aged gracefully if certain structural and historical factors had been taken into account and xenophobia actively combated. I may add that this discussion is confined to developments in the global north, that is to refugee law and to the global north. I'll proceed as follows. First, I'll make a few further remarks on how to approach the question of the convention aging gracefully. Second, I will suggest that mainstream refugee law scholarship, the dominant approach in refugee law today, adopts an internal approach that does not adequately take cognizance of structural, historical, ideological, and technological factors with a bearing on refugee protection. Therefore, I would suggest it does not possess the intellectual resources to make a strong case for allowing the 1951 Convention to age gracefully. Third, I'll identify some structural, historical, cultural, and technological factors that have a bearing on this question as to whether the 51 Convention is aging gracefully or not. Finally, I'll offer some suggestions for the way forward. But at first, as I said, I want to say something more on how to interpret the question posed. Often the manner in which a question is formulated predisposes your response. Whether you answer it in the negative or in the affirmative, you remain trapped within the boundaries constructed by the question. In this case, the question tends to limit you to the 1951 Convention, or what I call the internal approach. The reality is that the success or failure of any legal instrument or legal institution in any phase of its life is not determined by its internal features alone, but in crucial ways by the larger ecology within which it assumes life and evolves. It is not as if an individual convention or agreement cannot be evaluated by its internal features, for it does possess a distinct identity and ego. But such evaluation, at least from a post-colonial perspective, is of secondary order. The appropriate way to examine and assess the convention is by locating it in the matrix of the nature and character of international order in which it originated and evolved in its different phases. There's nothing particularly novel about this proposal. A moment's reflection will tell us that the convention has worked differently in different phases of its existence. Thus, it worked as a liberal instrument in the course of the Cold War, when any individual who fled the Soviet bloc nations was welcome as a refugee. But it turned into an instrument of containment with the end of the Cold War, with the movement of refugees assuming a South-North dimension. It is important to remind here that no provision of the convention was amended in this period. To grasp what changed then, we have no alternative but to turn to the external factors that produced the restrictive regime. But the dominant mainstream refugee law scholarship, which adopts the internal approach, does not do so adequately, as I suggested. For it, the central questions pertain to the elements of the definition of refugee and the regime of rights, the manner in which provisions of the conventions have been interpreted in different jurisdictions, aspects of international human rights law, the legality of elements of the non-entry regime, and the nature of UNHCR supervision. It by and large avoids getting into structural, historical, and such like convention. I must, however, admit that despite the formalism, a significant section of the mainstream scholarship espouses the cause of refugees by bringing a liberal outlook to the interpretation and application of the 51 Convention. The weakness of mainstream scholarship is that because it does not advance its views in the matrix of structural and historical factors, it finds it difficult to make a persuasive argument for allowing the 1951 Convention to age gracefully. What is more, even within the domain of law, a positive law, mainstream scholarship does not do two things among others. These are by way of illustration. First, there is by and large silence on issues like revisiting the definition of refugee, whether to include gender as a ground or to include the extended definition that we find in the African Convention. Indeed, you are told, often in the sidelines of conferences, that if you reopen the question of definition, the convention itself may come under threat. But you are never told why, in contrast to the refugee definition in Africa and Latin American nations, which has worked well, that it cannot be worked in the global north. Second, in the hermeneutic universe involving interpretations of different provisions of the convention, mainstream scholarship tends to confine itself to legal materials from the global north. Thereafter, as Professor Thomas Spiker-Boer has pointed out in a recent essay, interpretations of the convention and international human rights law emerging from this mainstream scholarship are attributed universal application. The northern bias in international migration law results, in his view, in the erasing of, and I quote, in the erasing of sources of international migration law from the global south, including refugee law. Professor Spiker-Boer notes how the views of global south institutions, such as the case law of Inter-American Court of Human Rights or African Commission on Human and People's Rights, or for that matter, the Kenyan High Court or the Colombian Constitutional Court, receive little attention from mainstream scholars. Leading journals also tend to reflect the opinion of mainstream scholars in the global north. Of course, I must admit again, the responsibility for this must also fall on scholars from the global south for not highlighting the contributions of institutions in the institutions present there. But by and large, materials of the global south are ignored. In short, the internal approach relies on a constrained formalist tradition to respond to the question of the relevance of the 1951 Convention today. As a result, its critique of the policies of the policies of nations of global north are ineffective. Let me now say a few words on the external approach to the question of the relevance of 1951 Convention in global north today. There are at least 4 dimensions that need to be taken into account that have a bearing on the question, and which I've already mentioned. And these are structural, historical, ideological or cultural, and technological. A few words on each of these factors in the context of the restrictive policies of global north are in order. These either explain the reasons why 1951 Convention is not aging gracefully, or conversely, if taken into account, would allow suitable changes to be made to it to ensure that asylum seekers and refugees are not prevented from accessing its safety and care. On the structural plane, turning to the first factor, on the structural plane, there are at least 3 logics that have for centuries determined the evolution of the global order. And these are the logic of capital, that is universalizing capitalism since the 16th century, the logic of territory, that's the sovereign state system, and the logic of culture, or one could say the ideologies of capitalism and imperialism. It is these 3 logics in combination that explain the phenomena of colonialism and neocolonialism and have accounted for the nature of migration flows over time, including shaping the responses to them. The 3 together, that is the 3 logics together, are also responsible in the Anthropocene for the climate crisis and climate refugees. The very same logics also constrain the functionings of any legal instrument and legal institutions in the global order. Thus, I would say, in a bourgeois global order created by these 3 logics, it is not humanity and solidarity that drives migration regimes, but factors such as the needs of advanced capitalist states and or the dominant culture and politics present in them. It compels us to look at the history of migration since the emergence of capitalism in the 16th century as the backdrop in which to consider the question whether the 1951 Convention is aging gracefully. Insofar as the history of migration is concerned, a post-colonial history of migration points out how in the colonial phase, slave and indentured labor was used in the global north for the primitive accumulation of capital. In fact, by 1770, and here I quote the classic book, Age of Migration by Stephen Cassels and Mark Miller, that by 1770, there were nearly 2.5 million slaves in the Americas, producing a third of the total value of European commerce. By 1850, the number of slaves taken to the Americas increased to nearly 15 million. The major colonial powers also used indentured labor from colonized nations. In the period 1834 and 1941, this involved about 12 to 37 million workers. In this era, there was also voluntary movement of people from the West to what were often arbitrarily designated empty spaces or terra nullius. From 1800 to 1930, 40 million Europeans migrated permanently overseas, mainly to North and South America and Australia. Often force was used by European settlers to take away the land of indigenous peoples across continents, turning them into aliens in their own lands. The cognizance of these historical episodes of forced and voluntary migration helps place in perspective the current volume of South-North migration. According to Ajit Ghosh, an ILO economist, if the same proportion that had emigrated from the global South since the Second World War as left Europe between 1850 and 1920, 800 million people would have moved north, expanding the total population of the more developed countries by 70%. Instead, and I quote him again, a negligible 0.8% of the workforce of developing world has migrated to work in industrial countries. 1/20th of the fraction of Europe's population that emigrated in the earlier period. And asylum seekers and refugees, we must remember, are only a fraction of the 0.8%. If this history had been kept in mind, the 1951 Convention could have been said to age gracefully by broadening its scope and giving its provision a liberal interpretation to welcome refugees from the global South. But instead, a non-entree regime has been established. What is as distressing is that most of the recent refugee flows have taken place because of Western interventions in the global South, be it in Afghanistan or Iraq or Syria or Libya. Yet refugees fleeing these nations are not always welcome in the global North. Turning now to cultural factors, it'll just suffice to quote the UN Secretary General, who has recently observed or noted with grave concern that xenophobic, and I quote, that xenophobic and racist responses to refugees and migrants seem to be reaching new levels of stridency, frequency, and public acceptance, quotes closed. It is no accident, therefore, that critical race theory and post-colonial theories are currently under attack in many places, which includes the United States, France, and Denmark in recent times. For the 1951 Convention to age gracefully, these negative trends, including nationalism and populism, need to be combated by progressive sections of civil society. To quote the UN Secretary General once again, the tenor of policy and public discourse on migrants and refugees must be shifted from one of threat to one of international solidarity, the protection of dignity, and a recognition of the positive contributions made by refugees. Finally, to the last factor that I wanted to touch on, and this is the technological factor. I list it as a separate factor as it is coming to play an important role in the asylum regime. A post-colonial perspective suggests that technology is not neutral. Its uses are, among other things, a function of power. In view of the prevailing cultural milieu in the global north, it is no surprise that the new digital technology is being used for the policing of asylum seekers and refugees. One recent report notes, and a report brought out by Petra Molnar and her colleagues notes, and I quote, technological experiments in various domains, it underlines the technological experiments in various domains, such as border enforcement, decision-making, and data mining. These experiments range from big data predictions about population movements in the Mediterranean and Aegean seas to automated decision-making in immigration applications to artificial intelligence, lie detectors, and risk scorings at European borders, quote close. The use of the new technologies is, as the report goes on to point out, often justified under the guise of needing new tools to manage migration in novel ways, but overlooks the profound human rights ramifications and real impact on human lives. The report also notes, of course, the growing role of the private sector in the governance of new technologies, a subject to which I will presently return. Now, once you take into account these external factors, you realize that the 1951 convention could have aged gracefully if each one of these had been evaluated properly. Instead, as I mentioned before, what we have is a plain policy of containment. I do not wish here to go over different generations and elements of the non-answer regime and its tragic human costs. I think most people in the audience would be more than familiar with these measures. Instead, I will merely illustrate how the logics of capital, culture, and technology are shaping the implementation of the 1951 regime in one instance. As noted earlier, private capital is coming to play a crucial role in the construction of what has been termed border industrial complex, which has been described as a confluence of border policing, militarization, and financial interest. To give you an example, it has been reported in The Guardian, and I'm quoting The Guardian, that a single company running Australia's offshore processing regime on Nauru has been paid more than $1.4 million over the past 5 years, with an additional $221 million added 2 months ago, despite, and that's interesting, despite no new asylum seekers arrivals on the island since 2014, and a steadily diminishing number of people it is responsible for. In all, The Guardian goes on to point out, government figures show offshore processing cost to Australian taxpayers is more than $9.2 billion between 2013 and 2020. This outsourcing of public responsibility is not an isolated event, but is becoming a broader global trend. The result is, and I quote The Guardian again, that defense companies and weapons manufacturers have become deeply embedded in the border industry, with deterrent measures being externalized beyond actual border controls through artificial intelligence, biometric technology, autonomous land and sea border, surveillance robots, offshore incarceration, and physical turnbacks of asylum seekers. But as if this was not enough, most recently, almost as a follow-up, Australia has enacted the Migration Amendment Act 2021, which allows mandatory indefinite detention of asylum seekers and refugees, where a person has had their refugee visa cancelled but cannot be deported because they could face persecution in their home country. As Australian critics themselves have pointed out, and I quote, "There's a real risk that detention may become indefinite, particularly where the circumstances in the relevant country are unlikely to improve in the reasonably foreseeable future." Quote close. But Australia cannot be deterred, and any reference to historical migrations that is seen as irrelevant today and need not be a factor which is considered. I cannot but comment at this stage briefly on the outcome of the COVID-19 pandemic. Amidst the already extant restrictive regimes in the global north came COVID-19. It has further helped legitimize border control measures, undermine democratic protections, and provided an excuse for disregarding the principle of non-refoulement. In more than 70 nations, and there is no north-south divide here, refugee groups do not have easy access to vaccines and drugs, both as a result of vaccine nationalism and because of not being prioritized. Where travel restrictions have been done away with, this is with a class bias, as restrictions against business and tourism are lifted without doing so against asylum seekers and refugees or labor migrants. In other words, states have seized on the pandemic to establish rules that disempower asylum seekers and refugees. Earlier, 9/11 had, to a certain extent, played a similar role. You thus now have a new normal non-entree regime. I now want to say, in the concluding section, a few words on the way forward. But at first, a word on the dialectical perspective. It keeps both the, as I said, it keeps both the internal and external approaches to the 1951 Convention in mind and helps frame a principled but pragmatic approach without abandoning the struggle for a just refugee regime. But even modest proposals would only be accepted if these are reviewed in the matrix of structural, historical, and cultural dimensions of forced migrations that I mentioned. Keeping these in view, let me list some suggestions that have not received enough attention. The list is endless, so I'll mention just a few suggestions that I had in mind. First, refugees and asylum seekers must be given a voice in the shaping of refugee policies. Following what has been called the all-subjected principle, a case can be made for democratic inclusion. The all-subjected principle claims that all those subjected to political rule in a given territorially bounded political unit should have a say in such a rule. They are not to be treated, as one commentator has pointed out, as transients and excluded from the application of the all-subjected rule. It has also been argued that political rights can be had without possessing citizenship. In other words, refugees should be allowed a voice in the making of domestic policies and laws on refugee protection to ensure that these are in conformity with the 1951 Convention. Some mechanism, in my view, for consultation needs to be worked out. If such a consultation regime is established, it could lead to the dismantling of some of the worst features of the non-answer regime. Second, the definition of refugee in the 1951 Convention needs to be revisited. I have no doubt that states and official spokespersons in the global north are going to reject this out of hand. But progressive sections of the academia and civil society groups need to advocate and persist in this regard. My view is that you have to push forward if you're not to be pushed further back. In this and other regards, voices from Global South need to be heard and foregrounded. Third, we need to campaign for an old proposal that many have advanced, that is to establish a refugee rights committee on the lines of Human Rights Committee. We need a body of independent experts to determine whether measures taken by a member state are in conformity with the convention. This cannot be left to the UNHCR, which is so reliant on donor nations from the global north. Fourth, we need the urgent regulation of new digital technologies that are being used for surveillance and admission of asylum seekers. I would call for a UN declaration on the lines of the 1998 IDP declaration, which distilled and collated relevant provisions for human rights instruments relevant for the subject. Fifth, we need the regulation of private sector involved with asylum seekers. I think, in my view, researchers need to examine whether the 2011 Ruggie Principles on Business and Human Rights can serve the purpose. There are several articles there, such as 5, 11 to 13, 17, whose application should be explored. Finally, we need to articulate and promote the principle of solidarity, which Professor Obiora Okafor, UN Special Rapporteur on the subject, has elaborated in several reports. Without human solidarity, all is lost. Only the spirit of solidarity can produce just responsibility sharing. All these changes, of course, cannot come about without critical scholarship and active intervention of the progressive sections of civil society. Allow me to conclude with the hope that both can come together and bring about the conditions in which the 1951 Convention can age gracefully. Thank you so much for your patience and for your indulgence.
Many thanks indeed, Professor Chimni. Absolutely wonderful to have you here, part of the conference this year, and giving your really informed, grounded, theoretical perspective on this question about the aging of the Refugee Convention. It's particularly notable your call to us as scholars, analysts, to put the convention in this broader external context and to think about the intersection between, if you like, the internal dynamics of the convention and the external dynamics. I thought also one phrase of yours early on particularly resounded, which was the idea of a just global refugee regime. And on that note, I know that we've got a large number of questions coming forward. So the format is that I will try and go through those questions one by one, posing them to you so that you are able to give your response to them. Many thanks again for the presentation. The first question that you have, Professor Chimni, is how far do you think the possibilities of a regional convention for refugees in South Asia exist, especially given the absence of the 1951 convention? So I think this is reflecting on your points about the fact that it was possible in Latin America and in Africa to develop regional tools. What prospects do you see there in South Asia? And this question comes from Sritapa Chakrabarti.
The short answer is that the prospects are very, very remote for a regional convention in South Asia or Asia on the lines of the African Convention or the Latin American Cartagena Declaration. We must also remember that Asia, unlike the other regions, does not also have a regional human rights convention. So there is some talk of Asian exceptionalism, but the reasons for which can be explored. But the short answer is no, it is not on the cards.
Okay, many thanks. A simple answer to perhaps a complex question. The next question is on a slightly different tone. And again, it's about how we frame some of these debates. And it asks, how can we, as academics, given that international law is premised on a system of sovereign, equal, but substantively unequal states, persuade states and communities around the world to open up borders for refugees and asylum seekers? How can we tackle xenophobia nationally and locally, given that capitalism is here to stay? So a fairly far-reaching question. Would you be happy to offer some comments on that?
Yeah, no, as you've said, that this is a very complex question, and but I entirely understand the reason for asking it. What I would say is that, so far as academics are concerned, and that was the sort of the tenor of my paper, we at least should make an effort at decolonizing refugee studies, and by trying to educate the wider public, about global migration patterns over the centuries, so that this particular phase of south-north migration is not seen as an exceptional moment in history. Besides this, of course, just the task of civil society organizations, social movements, and liberal and left-wing political parties to weigh in to try and reverse the xenophobic discourse, which seems to be gaining ground every day.
Many thanks indeed. This is a question, I think, which perhaps draws on some of the historical aspects of your earlier presentation. I should have said that the previous question was from Elizabeth Mavropoulos, and the current question comes from Aman. And it's asking really about this value of solidarity. And I think what it's asking is, how far can one push solidarity, or how does one help to push solidarity given the situation of refugees in these populist contexts? What does the concept of solidarity really do for us there, and how can we develop upon it?
Again, a great question. So one, of course, I would recommend reading Professor Oviora-Okafor's reports. The other is that when you're calling for solidarity, this call for solidarity has to be based on a deep analysis of the trends within society, a deep analysis of those structures which tend to create hurdles for the expression of solidarity, etc. A third level at which we can think about solidarity is at the level of governance structures. For example, we know that even while states in the global north have been implementing measures, there are several cities that have taken the initiative for welcoming refugees. So, in other words, one is the principle of solidarity, and this principle of solidarity has to be articulated on the basis of a sound analysis of both deep structures and current trends in migration. And second, we have to find mechanisms and ways by which this solidarity can actually be reflected on the ground, such as, for example, allowing decentralization in decision making. Sao Paulo in Brazil, in the global south, is another example of how cities are, taking the question of solidarity forward.
Many thanks, Professor Chimni. And continuing with the quickfire question style, I've got a question here which asks, would you suggest that apart from the problem of limited grounds of recognition, the Convention's definition of a refugee allows states to attribute a default illegal migrant identity to displaced populations, allowing them to be criminalized? Any thoughts on how this criminalization trend could be combated? And that's from Ishita Kumar.
Yes, I think from a very, very academic standpoint, the process of promoting solidarity and promoting decriminalization of illegal migrants is the same. You would see that those that you have populist and nationalist regimes which are doing both. They are not only fostering xenophobia, but they are also criminalizing illegal migrants. So they are part of an integral integral problem. And so if we have to push back, we have to push back on all these fronts, if one may put it that way, simultaneously. Yeah, so that's the short answer that I would offer.
Many thanks indeed. So the next question is on one of the remedies that you've suggested, and it asks what a refugee rights committee might look like in practice and what role historical conditions would have in this. And just before answering, I should say that that was also one of the recommendations that our keynote yesterday was very keen to advance. So it's interesting to see two such eminent thinkers in the field converging on this point. So what would a refugee rights committee look like in practice, and how do historical conditions play into what that, the shape of that might be?
Yeah, I think the reason why, my Professor Hathaway and I recommend the creation of the Refugee Rights Committee is the same. As I mentioned, that while the UNHCR is rendering, exemplary sort of service to the international community in promoting refugee protection, it simply is too constrained by donor nations to perform effectively the role of supervision. Now, what would a refugee rights committee look like? Like I said, that if it is possible to get states themselves to create on the lines of treaty bodies in most international human rights convention, at the initiative perhaps of the executive committee of the UNHCR, a separate distinct body of independent experts. But if states are unwilling to agree to such a proposal, then I think the international civil society or the global civil society should take this initiative, because I think it's very important to get an independent voice or opinion on a large number of the measures for example, the non-entree measures, and these could be in the global north or in the global in the global south. And it would greatly strengthen both civil society activists as well as the academia in arguing for progressive reform. And these independent experts would be people with great degree of credibility and whose views would be taken seriously by the international community of states.
Thanks ever so much. We've got a question again, which is rather forward-looking for you now, Professor Chimni. And I should have said the last question was from Patricia Hines. This one is from Yuri Hursta. And this question asks, what lessons can or do we have to draw from the described colonial roots and resulting bias when it comes to concerns about climate-induced displacement and global justice, particularly global climate justice?
So I would say I'm sort of presently trying to study this issue, but clearly if we are trying to look at the attributing responsibility for climate change, we have to go back in history. And there are many who trace what we call early Anthropocene to the 19th century, and which is to the Industrial Revolution, which was also the high era of imperialism. And therefore, one could argue that it is this combination of global capitalism and imperialism, which is in some senses primarily responsible for the climate crisis, and as a result of which climate-induced displacement, and therefore, the accountability, as has been said in innumerable sort of writings, rests with those nations. To offer protection to those who are externally displaced by climate change. So again, what I'm trying to do is to link and bind these questions of historical trends in migration, colonialism, and the current climate crisis together, and build on it to find a just response.
Many thanks, and we'll look forward very much to seeing that when it's published. I'm sure there'll be many of the conference participants who await that publication with great interest. We have a number of questions still. I'm very grateful to you for continuing to take them at such great speed and offer such nuggets of insight in return. We have a question now about the post-colonial international legal order, and this comes from Ruben Vissing, and he says, how would you imagine a just refugee protection system in a post-colonial international order, where the external dimensions you've addressed are in fact included? So would a binding burden and responsibility sharing mechanism be a sufficient guarantee for a just system, or would other things need to be put in place? So I think the key question there is, what does a just refugee protection system look like in the post-colonial international order?
Yeah, again, a very good question, but a very complex question. But my sense is that let's begin with doing away with the worst elements of the current non-entree or restrictive regime. Just imagine if you can take away, the 2 or 3 generations of restrictive measures that have been put in place. That itself would go a long way, along with a reconceptualization of the definition, would go a long way to create a reasonably fair global refugee regime. In the ideal world, of course, there would be no refugees. And so I'm not certain, but I imagine that the fact that the UNHCR was created for only a few years, I think 5 years, what the initially life, that those who created the organization also imagined that there would be no refugees after that period of time. So ideally, the best world or a utopia would be a global space where there are no refugees who call for protection. So in some senses, the advance in refugee protection is very deeply linked with the with bringing about other transformations in the global order, and that we can foresee invites us all to a very long and enduring to be part of a very long and enduring struggle. But I would say first get rid of all the non-answering measures. That itself would result in reasonably just responsibility sharing.
Okay, many thanks. We changed gear a little bit for the next question, which comes from Suraj Girija Shankar. And it says, you've highlighted the imbalance in academic knowledge production between the global north and the south. What steps do you suggest we can take to address this imbalance in the refugee law field or the refugee protection field?
No, I'm not. I'm not certain I got the question. My apologies, but can you repeat the question, please?
Okay, so we have a question here about knowledge production, and they've said that given the imbalance in academic knowledge production between the global north and the global south, which you've highlighted, what steps do you suggest can be taken to address this imbalance in knowledge production, particularly in the refugee law or refugee protection field? What could we do practically to overcome these imbalances?
Thank you. Yeah, I think this is again a very, very critical question. How do we change the dynamics, the internal dynamics of knowledge production? First, of course, we need to promote refugee studies, critical refugee studies in the global south itself. There are some centers in the global south, but I think these need to be much more proactive in producing knowledge about refugee flows, protection, different theoretical formulation which emerged from the global south. So first is, of course. Second, I think steps can be taken also in the centers of refugee knowledge production, which is in the global north, to try and bring voices from the global south to the fore. And we've seen actually several, or not several, but I've seen at least one or two analysis of the publication over time in leading refugee journals like the Journal of Refugee Studies, the International Journal of Refugee Law. And the fact is that they publish very few scholars from the global south. I think some efforts can be made there, especially to bring, I don't want to say much because I've been overly critical in the past because I found that there is a division of labor. Even when Global South scholars are published, they often sort of are reflecting on particular refugee flows in the Global South, particular episodes. What I think is needed is to actually encourage the publication of an alternative imagination, if one may put it that way, about refugee studies, which you can find in the Global South. So there are some measures that can be taken as a part of this collective effort. I must add that most journals are very encouraging and wish to publish writings from the Global South, but I am not sure what the reasons are for still this not adequately reflecting in terms of terms of numbers. Finally, of course, we know that there is this disparity knowledge production across the social sciences, and that has to do with the resources, etc., that are available in the Global South within the university system. And I know how difficult, even today, it is to get access to recent access to literature, etc. So there are several, I should stop there. There are several ways that we can try and attend to this disparity.
Many thanks, Professor Chimni, and I'm sure we're all taking very careful note there. You've really been very patient with a very large number of questions and answered them very pithily and very directly. Can I just finish with a final question in the last minute? And I'm very sorry to the other participants who've put in a list of questions, both in the private forum and public forum, which we won't have time to get to. But the next one that I have on the list here is from Martin Jones, and it switches the focus a little way away from international law. Now, his question to you, Professor Chimni, is, do you see any hope for responding to forced migration, less through international law, for all the reasons you mentioned, and more under local legal frameworks? And then, notwithstanding the Indian Supreme Court's recent decision, can we, with any hope, draw upon more indigenous or local norms founded on local traditions of hospitality and protection in our legal advocacy? So I think that may be a nice question on which to leave with your thoughts.
Yeah, I really don't have sufficient sort of knowledge, ground level knowledge of different local practices that could be drawn upon, relied on to promote refugee protection rather than international law. And there are 2 or 3 ways that we can try and explore this. One, of course, like I said, there are already researchers looking at the response of a network of cities to refugee protection, and these cities are trying to overcome the constraints that are imposed by the national governments. A second area worth looking at is what happens in countries such as Asia, where only 7 or 8 countries are parties to the 51 Convention. How does refugee protection work in those nations where there is no, they are not party to the International Convention, neither do they have domestic laws dealing with the status and rights of refugees, as in South Asia. No country has a law on the status of refugees. So that's another area that is worth exploring. And then, of course, looking at the practices of local communities, indigenous peoples over time, historically, how they have responded to, to the protection needs of individuals or groups. So my sense is that this is a very productive area for research, because in the short term, at least, governments are not going to be changing their views. But I didn't want to. I don't want to end in a pessimistic note. I remember 15 or 20 years ago, I was invited by the British Academy to talk on refugees, and I ended on a very pessimistic. I said that I will not see a change in my lifetime. And people said, no, you're being alarmist and you're being pessimistic. And I've often been critiqued for this, but that is the reality that we are faced with. But nevertheless, I think exploring alternative practices, alternative imaginations, gives us, or establishing new mechanisms, allows us to create space for this alternative discourse, create space for alternative practices. And we can together do no more than that.
Well, thank you ever so much, Professor Chimni, for bringing the second day of the conference to an end on such a high note. It's been a real pleasure to hear from you. Your presentation was obviously greatly enjoyed. Just looking through the comments in the chat box, wonderful, brilliant. I want to listen to it again. When's the podcast available? All of those sorts of comments. So obviously your intervention here has been greatly valued, and I'd like to thank you personally on behalf of all of the participants and the Refugee Law Initiative, not only for the presentation, but also for responding so incisively to such a wide-ranging and far-reaching set of questions about big picture issues, and giving real insights to each of those, but tying them all the time back to this idea that we need to understand this particular convention, refugee law more generally, in its wider structural, cultural, historical context. A really fascinating end to today's session. So again, thank you very much for that. For the rest of the participants, thank you ever so much for your questions, and apologies if we didn't get time to get down to one that you may have put forward. We hope that you'll join us for the final day of the conference, or half day of the conference, tomorrow, which starts at 1 p.m. British summertime. So thanks everybody for your participation. Thank you again to Professor Chimni for giving us such a wonderful keynote, and I shall look forward to seeing all of you tomorrow. Goodbye.
Thank you. Thank you all as well. Thanks to everybody, all the participants, to you, David. Thank you.
A great pleasure. Have a good evening.